My topic is estate planning for clients in the earlier years. So let's meet our client. Some of you may know him, Ron Swanson from Parks and Rec. Ron Swanson believed that he had the perfect estate plan. He had the same will since he was 8 years old. So let's look at what his will actually said. Upon my death, all of my belongings shall transfer to the man or animal who has killed me. Ron Swanson. So he thought that this had all of the perfect elements. It was on good, thick quality paper. It had red lines, never mind that the lines went horizontally instead of vertically. He had defined terms. You'll notice that animal and man are both capitalized. And he used arcane language, or in his case, symbols that were difficult to understand. Never mind the fact that the killer would have had to actually witness Ron's signature for the will to be valid in the state of Connecticut before killing him. So, as we know, some of our clients do have wishful thinking like Ron, who believe that they don't need a simple estate plan. So some examples of this type of wishful thinking might be, won't my assets go to my spouse and kids anyway? So this is partially true. If your spouse remarries, though, the property that's left to them is subject to rights of creditors, such as a divorcing spouse. So it's possible for those assets to be diverted that could have been protected for that client's descendants. Another example, my heirs can figure it out when I'm gone. I don't want to overcomplicate things. And you see this all the time, not just in terms of the client deciding whether or not to do an estate plan, but also in terms of the planning for their heirs. People react to death in very unexpected ways, and the more planning that can be done, oftentimes the simpler the heirs will have it. We see clients leave their philanthropic legacy up to their spouse, not do any philanthropic planning themselves, leave it to their children or spouses as to who manages the money or what the family's investment philosophy is. And also distribution philosophy and what their money is meant to actually fund and what distributions from trusts they would actually like to support. Examples of things that are simple enough to put in an estate plan but are difficult to figure out if you haven't done the basic planning. Another one, some clients say, well, I have life insurance. Isn't it tax-free? Income tax-free, yes, but not estate tax-free. So to get it out of the client's estate, you have to do some basic planning to accomplish that. So in the real world, otherwise known as Pawnee, Indiana, there are other considerations that you have to take into account. So in this real world, intestacy means that state law controls who manages your property and who receives your property. So this may result in transfers to unintended beneficiaries, where, in our example, somebody dies intestate with a spouse and kids. The spouse gets the first $100,000, and then the estate is split between the spouse and the children. This means that this could impose tax on that person's death when it could have been deferred or completely eliminated by a basic estate plan. The court would also get to appoint guardians and executor, rather than the client simply, sitting down to do a revocable trust and will and selecting those individuals themselves. And of course, not being clear about one's directions or who they want to appoint doesn't make things easier for the family. It, in fact, creates a breeding ground for disputes. So encourage young clients, and all clients really, to prepare for the worst and hope for the best. So here's an example of the youthful, exuberant, optimistic client who comes in thinking that everything's going to work out just fine. But we know that the reality can be quite different. So our job really is to make sure that our client and ourselves don't end up on the website that I found this picture on, which is www.sadanduseless.com. So with effective estate planning, to manage through the realities of the legal world today, the client controls how and to whom assets pass. They select their executors and basically who's in charge of their property. And they get to accomplish effective, simple, and flexible estate planning. And I think that's one of the most important things, even in the exemption environment that Rachel was talking about. And the simple plan really assists to avoid some of the unforced errors that are just costly and difficult to administer in an estate. such as finding a probate bond or managing multiple probate proceedings at the same time. If, in Rachel's example earlier, if a client has property in New York and Connecticut, simply by transferring real estate in New York to a revocable trust, you can solidify the estate into the Connecticut probate proceeding and not have to probate the New York real estate. And that planning ends up saving a tremendous amount of money for the family down the road. So when we meet with clients in their early years, we want them to walk away with the core estate planning documents, which, in our view is a revocable trust with a pour-over will, durable general power of attorney, advanced medical directives, and life insurance trusts if the client's policy is big enough to warrant that. Also, to make the plan effective, as you all know, the assets have to be coordinated with the estate plan. So you want to check that your beneficiary designations are going to the right place and that the asset ownership is where you want it to be. In the classic example, to take advantage of the $2.6 million Connecticut estate tax exemption that Rachel referenced, if one spouse has $5 million and the other spouse has $100,000, if the first spouse dies, you're not going to be able to take advantage, if the spouse with $100,000 dies, they're not going to be taking advantage of the $2.6 million exemption. So you want to make sure that your clients have balanced assets so that they can take advantage of credit shelter trust planning. So, taxes, I think, are one of the things that our firm does best and that we help clients understand. So let's look at an example of how a simple estate plan compares to the tax-efficient plan that you'd get from a Cummings and Lockwood document. So the example on the left, where you have a $10 million estate passing to the wife through what's called an I love you plan, where it just gives everything outright to the wife, that would attract $723,000 of Connecticut estate tax at the spouse's death. In comparison, the tax-efficient estate plan on the right, which is the credit shelter plan or the AB plan, funds that credit shelter trust with the $2.6 million estate tax credit from the state of Connecticut. So that pool of assets is outside of the wife's estate. So when the wife passes away years later at $7.4 million, her tax is $431,400. And I think this is important to highlight that the tax savings is $292,000. I think all of us have gotten used to the tax savings of these plans being higher, but I think it's important also to note that $292,000 is still an important amount of money and still worth doing the planning for. So I think it's helpful, and Rachel Zargami actually gave me this idea from the last presentation, to think about what it is that $292,000 buys you. One thing it could fund is a full years of tuition for 30 full-time literacy and life skills students at your local charity, or the purchase of 3 Porsche 911 Carreras. So I think it's helpful to think about your clients driving away with 3 Porsches if they're resistant to the idea of doing a basic estate plan. In our second example, which I think the first example may have seemed a bit unfair because there are not that many young clients with $10 million of assets starting out. This client, I think, is an example that we might find more regularly in Fairfield County, and a lot of clients would walk in with assets that look something like this, where they have $2 million in the husband's name or the first spouse's name, and a $5 million insurance policy. In our example, this is the simple AB plan, but the beneficiary designation of the insurance policy was directly to the spouse. So you are able to fund the estate tax shelter trust at the husband's death, but because they only have $2 million of assets that pass under the revocable trust, that credit shelter trust is only funded with $2 million. The insurance policy goes directly to the spouse, and so she doesn't have sufficient exemption to shelter that in her estate, and that attracts a tax of $186,000 to the state of Connecticut. If you do a simple insurance trust, you'll see that the estates end up with paying no tax, and that's because the wife's estate fully shelters the $2 million passing to her estate, if you look at the middle flow chart there. And then on the right, you have the insurance trust that's funded and passes outside of the estate for federal and state estate tax purposes. So this results in tax savings to this couple of $186,000, which gets you 18 annual tuitions or 2 Porsche Carreras. So I have an estate planning conference coming up this afternoon. I'm thinking of bringing 2 Matchbox cars to my actual conference. I'll let you know how that goes. So I think the prior example also illustrates the importance of coordinating asset ownership and the beneficiary designation with your estate plan. Just by transferring the policy to an insurance trust, did save roughly $200,000 of tax. So some of the things you have to think about are, does the right person own the assets? Should an insurance trust be named the owner? Are there any restrictions on the assets that you're transferring, or any things that have to be coordinated with an asset transfer, such as property and casualty insurance, for example? And I think that plan also shows the limitation of transferring an insurance policy to a spouse as a simple estate planning strategy to get an insurance policy out of a client's estate. That works for smaller policies, but where the policy is large enough that you don't have exemptions to shelter the full amount of the death benefit if the second spouse dies, you may end up with tax unnecessarily, and the insurance trust would be a better option. Beneficiary designations are an important topic with all clients, and especially with IRAs, deciding whether or not to send the property or the IRA outright to a spouse, or putting it in trust for children. These things are, important to coordinate. I think a simple rule of thumb for IRA beneficiary designations is that, generally you'll have the maximum tax deferral if you send it outright to spouse. And for children, sending it to a trust that qualifies as a see-through trust for that beneficiary will provide additional creditor protection. And increasingly, I think clients are asking about whether or not, IRAs should be sent into trust for creditor protection reasons. So if we move on to insurance planning, and just I want you guys to take away a few simple concepts about the insurance trust, because it is a very simple and very effective estate planning strategy to protect your clients from significant amounts of tax, in these Northeast states where the exemptions are decoupled from the federal estate tax exemption. By funding insurance trust with cash and then purchasing the policy, you avoid what's called the 3-year clawback rule, which brings the life insurance back into the client's estate if they don't survive the transfer of the policy for more than 3 years. But transferring cash and then having a purchase of the policy avoids that rule. It's important also and easy enough to do to qualify the contribution to the ILIT for payment of insurance premiums for the annual exclusion from gift tax just by sending a crummy letter or a withdrawal right notice every year. And last tip is to file the gift tax return for the year of funding so that you allocate or opt out of GST exemption, and file returns periodically to update the IRS on how much exemption you've used from GST and gift tax. And a good rule of thumb there is that if you haven't filed a gift tax return reporting your transfers to the trust, in the last 5 years, you should definitely do that. Otherwise, you'll get into the pattern of never doing it, and then the records will be difficult to find and possibly incorrect, if your client dies. We also are going to talk about an example later on where we discuss insurance trust planning with 529 plans, and for these young clients, how to maximize annual exclusion gifts. The 529 plan is an effective strategy for a young client as well. If the withdrawals are made for qualifying education purposes, these function much like a Roth IRA, where you're sheltering the gains from tax and the withdrawals are tax-free. In Connecticut and New York, there's additional benefits, state income tax deductions from transfers to the state's plan. So in Connecticut, that's the CHET plan, and in New York, it's the 529 plan. And this is helpful because Connecticut has so few deductions from income tax. This is one of the few that it has. Not many young clients have amortizable bond premiums that I'm aware of. So this is one that they can actually take advantage of. New York also has a difference, and it's less generous than Connecticut. Under the new tax law, qualified distributions for K-12 expenses can be taken from 529 plans. New York recaptures the state income tax deduction that you got on the contribution. Connecticut does not. So you're still allowed the deduction even if you pull money out of the 529 plan for K-12 expenses. And the last point is just that 529 plans do allow you to front load gifts to the 529 plan. So putting in $15,000 a year or $75,000 in year one and then prorating the gift over 5 years is a unique feature that you can accomplish with a 529 plan. So here's an example of the power of doing a simple estate planning process each year of maximizing a client's annual exclusion. So our example is a married couple with twins. That allows them to have $60,000 of annual exclusion. They each have a life insurance policy. The total is $8,000 of insurance premiums that they have to pay. $5 million for spouse one, which is a $5,000 annual premium. $3 million for spouse two, which is a $3,000 annual premium. So those go to the insurance trust. They're sheltered by the annual exclusion. In addition, they fund 529 plans, the remaining annual exclusion of $52,000. So we're taking advantage of the CHET income tax deduction. So each client gives $5,000 to their CHET account, and then the balance is split between each child's 529 account at your preferred institution. You've noticed that we've assigned a 5% rate of return to the CHET account and a 7% rate of return to the preferred institution because we assume that you all will manage the money better than the CHET account would. In year 18, the family has substantial benefit from this relatively simple plan. So they've got $8 million of life insurance protection still outstanding, $1.84 million of college savings, which is a really impressive amount for annual exclusions, and this is all outside of the estate and free of estate and gift tax because it was sheltered by the annual exclusion. So $140,500 each CHET account, there are $281,000 total, and $780,000 in each of the children's 529 plans at the separate institution. So possibly enough to fund college education 18 years from now. Not going to guarantee that. So clients who are just starting out, we're taking the assumption that clients have a profile of many Fairfield County professionals, but your clients may also not be the typical client, and they may have assets like stock options from their company, interests in private equity or hedge funds, or they may be founders of a startup when they're very young, under 40, that have explosive growth potential. So just because the client is young doesn't mean that they shouldn't be doing grats or installment sales or other estate freeze and leveraging techniques to take advantage of the extremely high exemptions that we have right now, and also the time value of money. So it can be a good time to do that planning, for clients with unique assets like that. Thank you very much.